Law on Obligations Review, Part 1. Yung Part 1 ay about general principles. Yung law on obligations consists of 4 parts. General principles, nature and effects of obligation, kinds of obligations, and modes of extinguishment of obligation. Yung Part 1 ay general principles. Yung topics to be discussed dito sa Part 1 ay definition of obligation, elements of an obligation, and sources of obligation. Yung tatlong topics na to are very important. Ito yung parang foundation ng law on obligations. Definition of obligation. Obligation is a juridical necessity to give, to do, or not to do. Yung to give, to do, or not to do, madaling intindihin lang. Very self-explanatory. What is important dito yung juridical necessity. Dapat naintindihan natin kung ano yung ibig sabihin yan. Merong juridical necessity kung, say, for example, merong tao nagsasabi na meron siyang obligation at hindi niya na-perform, pwede siyang issue sa courts. Pwede siyang issue sa courts. Kung merong obligation na kung hindi i-perform, hindi siya pwedeng issue sa court, ibig sabihin, there is no juridical necessity. Yung definition ng obligation dito, juridical necessity to give, to do, or not to do, ito yung civil obligation. Actionable yan. So pag hindi na-perform, pwedeng issue yung hindi na-perform. Actionable. Kung hindi siya actionable, hindi yan civil obligation under the law. Example, moral obligation. Yung moral obligation is based on the conscience of a person. Hindi yan based sa law. Say merong obligation to help the poor. That is a moral obligation. Kung hindi i-perform ng tao, hindi siya pwedeng issue for that obligation. Baka walang konsensya lang siya dun. Hindi yan actionable. Walang konsensya, not actionable. Again, yung civil obligation based sa law, yung moral obligation ay based sa conscience. Next page. Elements of obligation. The following are the elements of obligation. 4 yan. Active subject, passive subject, prestation, and efficient cause. Madaling memorizein. Yung problema of some students, when they study, they just memorize. They don't understand. Kung yung tanong dito ay enumeration lang, kahit hindi mo naintindihan, kayang-kaya. Say, pinapa-enumerate yung elements ng obligation. Active, passive, prestation, and efficient cause. Yung problema ng nagme-memorize na hindi iniintindi kung yung exam ay application. Pinapa-apply yung mga terms or provisions ng law. Papa-identify sino yung active, sino yung passive, ano yung prestation, ano yung efficient cost. So, doon na magkakaproblema dahil hindi niya inintindi. So, dapat intindihin. So, meron tayong obligation, simple. Si D nag-promise na bigyan niya ng 10,000 si C. So, D promised to give 10,000 to C. Tingnan natin sino yung active, sino yung passive, ano yung prestation, and ano yung efficient cost sa simple obligation na yan. The active subject is the obligee or creditor in an obligation. Sa isang obligation, merong obligor and obligee. Merong debtor, merong creditor. Yung active subject, siya daw yung creditor. Sa ating example or illustration, sino yung creditor? Si C. Kasi yung merong obligation talaga dito ay si D. That is to give C 10,000 pesos. So yung active subject ay si C. The passive subject is the obligor or debtor in an obligation. So, sa ating illustration, sino yung passive subject? Si D. Siya yung debtor. Siya yung merong obligation to give 10,000 pesos to C. Ano yung prestation? Prestation is the obligation to be performed by the obligor. Sa ating illustration, ano yung prestation? Ano yung obligation ni D? To give 10,000 pesos. Yan yung prestation. Efficient cost is the thing or the agreement that binds the parties. Efficient cost. The thing that binds the parties. Ano yan? Yung agreement between D and C. Yan yung binding sa kanila. Yung efficient cost is also known as juridical tie or vinculum juris. So yan yung simple application ng elements of an obligation. Papa-identify yung mga elements sa isang situation. So kung ipa-complicate natin ng konti yung situation, tingnan natin yung application. Si X ay isang building contractor. Hinire siya ni Y. Si Y magpapakonstruct ng building kay X. Sa yung kanilang agreement, yung cost na babayaran ni Y ay 10 million pesos. Tapos, tatapusin ni X yung construction in 6 months. Sa yung agreement nagsasabi na hindi mo na magbabayad si Y until completion ng construction. So, pag complete ng construction, doon na magbabayad si Y ng 10 million. Yan yung scenario, yan yung situation. Ngayon, yung tanong, right after the signing of the agreement, sino yung active, sino yung passive, ano yung prestation, ano yung efficient cost. Right after the signing of the agreement, yung active subject, yan yung creditor, ay si Y. Wala pa siyang obligation. Yung obligation ni Y, papasok lang kung makomplete na yung construction. Yung passive subject, right after the signing of the agreement, yung debtor ay si X. So initially, siya yung merong obligation. Initially, walang obligation si Y. Maghihintay lang si Y. Ano yung prestation? That is the obligation to be performed by X. That is to construct. Again, right after the signing of the agreement, yung tanong. Yung efficient cost, yan yung agreement. Yan yung contract entered into by X and Y. So, yan yung right after the signing of the agreement. Say, right after the completion of the building, baliktad. Sino yung active subject? Si X this time. Siya yung creditor. Tapos na yung kanyang obligation, si Y na yung merong obligation. So, si Y yung debtor right after the completion of the construction. Yung prestation ay to pay. Yan yung obligation ni Y, to pay X 10 million pesos. Yung efficient cost, the same. Yung agreement pa rin nila. Yan yung thing that binds the parties. So, yan na yung application ng elements of an obligation. So, dapat naintindihan natin yung mga terms na ginamit dyan. Next page. Sources of obligation. Yung sources of obligation, merong connection to sa juridical necessity. Kung wala dyan sa sources of obligation, ibig sabihin there is no juridical necessity. Ibig sabihin hindi yan civil obligation. So dapat nandyan sa 5, any of the 5. Yung sources ay law, contracts, quasi-contracts, delict, and quasi-delict. Say for example, si S nag-offer kay B. Nabili ni B yung car niya for 100,000. Si B, nag-agree naman. Nabilhin niya yung car ni S for 100,000. So, S delivered the car to B. But B did not pay. So, ano yung mangyayari? S will sue B for collection. Sa court, dapat i-establish ni S na yung source ng obligation ni B ay nandun sa 5. Kung walang doon sa 5, ibig sabihin, walang juridical necessity. The case will be dismissed. Pero dito sa illustration na to, merong obligation si B kay S. At yung source ng obligation niya ay contract. Yung contract of sale nila ni S. Yan yung source ng obligation ni B. Yung obligation niya ay to pay S 100,000 pesos. So that is how it works. Dapat i-pinpoint ng creditor obligee kung ano yung source ng obligation ng debtor obligor. Otherwise, kung wala siyang maituro dyan, the case will be dismissed. Law. Obligations derived from law are not presumed. Only those expressly provided by law are demandable. Say si BIR nag-file ng case against the taxpayer. Doon sa court, establish ng BIR na merong obligation si taxpayer, na yung source ng obligation ng taxpayer ay galing sa tax code. Nasasabihin ng BIR na dapat yung ganitong transaction na ginawa ni taxpayer, magbabayad siya ng tax. Yan kasi yung sabi ng tax code. So yung source ng obligation ni taxpayer ay yung law. Another example, si illegitimate child nag-file ng case for support against the father. Ano ba yung source ng obligation ni father? Yung family code na nagsasabi na yung parent meron siyang obligation to give support to his or her child. So yung family code, yung source ng obligation. So yung obligation ni F nanggaling sa law. Contracts. Obligations from contracts have the force of law between contracting parties and should be complied with in good faith. Force of law. Ano ba yung ibig sabihin yan? Parang law daw yung contracts. Yung law, pag hindi mo sinunod, you will be penalized. Yung contract, pag hindi mo sinunod, you will be liable. Kaya lang yung law applies to all. Pero yung contracts apply to contracting parties only. Siyempre, kung sino lang yung pumirma, yan lang yung magiging liable as a rule. The source of obligation is the agreement of the parties. So, pwede nating gamitin as illustration yung example natin kanina, yung between S and B. Another example, yung lease contract between a lessor and a lessee. Kung hindi magbabayad si lessee ng rent, isusu siya ng lessor. The lessor will sue the lessee for collection. Ano ba yung source ng obligation ni lessee? Ay yung lease contract nila. So yan yung contract. Next page. Quasi-contract. As if contract. Pero walang agreement or walang contract. So quasi-contract lang. Is a juridical relation from lawful, voluntary, and unilateral acts by virtue of which the parties become bound to each other to the end that no one shall be unjustly enriched at the expense of another. Very important, no one shall be unjustly enriched at the expense of another. So yung quasi-contract is based on this maxim that no one shall be unjustly enriched at the expense of another. Say for example, si D umutang kay C ng 10,000. On due date, instead of paying C, D paid TP 10,000. Can C still demand payment from D? Kahit nagbayad na si D kay TP, C can still demand payment from D. So, magbabayad si D kay C ng 10,000. So, total cash out ni D ay 20,000. Yung gagawin niya, i-recover niya yung 10,000 kay TP. Kung wala tayong provision about quasi-contracts, D cannot recover from TP dahil hindi yan law yung source ng obligation ni TP. Hindi rin contract Walang agreement between D and TP. Hindi rin yan delict at hindi rin yan quasi-delict. So yung mangyayari, hindi makaka-recover si D kay TP. So TP will be unjustly enriched at the expense of D. Hindi pinapayagan ng law yan. So pwedeng i-recover ni D yung binayad niya kay TP by mistake. Yan yung quasi-contract. No one shall be unjustly enriched at the expense of another. Common forms of quasi-contracts. The Civil Code mentions several forms of quasi-contracts. The most common among them are negotiorum gestio and solutio indebiti. So aside from the two, there are other quasi-contracts na mga provisions sa Civil Code. They are all based on the maxim that no one shall be unjustly enriched at the expense of another. Yung example natin kanina, yan ay solutio indebiti, payment by mistake. Ano yung negotiorum gestio? Is the voluntary administration of the property, business, or affairs of a third person without the consent or authority of its owner. Voluntary administration or management of the property of another without the consent or authority. Kasi pag merong consent, contract na yan. Hindi na quasi-contract. Pag merong authority, actually contract din yan. Agency. So dapat walang consent, walang authority from the owner of the property. Say for example, si F1 and F2 are farmers. They are neighbors. They are adjoining lot owners. They are friends. Magkasabay sila nagtanim ng palay sa isang month ng May. Yung target date of harvest nila doon sa last week of August. Kaya lang, nung August, si F2 ay pumunta sa abroad. Nagbisita sa anak niya or sa apo niya. Sabi niya, babalik lang siya in time for harvest sa last week ng August. Pero doon sa last week ng August, hindi pa bumabalik si F2. Merong balita na merong super typhoon na dadaan sa place nila. At yung place nila parating binabaha. So si F1, pinaharvest na kaagad yung palay. Doon na kasi yan sa last week ng August eh. At nagtaka siya after harvesting his plantation, yung kay F2 nang doon pa. Pinatawag niya yung tao ni F2, sabi niya walang instruction kay F2 at wala siyang pera para mag-hire ng tao para ipa-harvest yung plantation. So yung ginawa ni F1 as a good neighbor, concerned neighbor, siya yung nag-hire ng tao para ipa-harvest yung plantation ni F2. Yan yung voluntary administration. So dito, pagbalik ni F2, dapat i-compensate niya or bayaran niya si F1 ng lahat ng ginastos ni F1 para ipa-harvest yung plantation. Kasi baka babaha doon sa place eh. Hindi pwedeng sabihin ni F2 na wala silang agreement ni F1. So hindi niya babayaran si F1. Papasok na naman dito yung maxim na yon Pag hindi mo inallow sa F1 to recover the expenses or lahat ng amount spent by him para mapaharvest yung plantation F2, F2 will be unjustly enriched at the expense of F1. So yan yung negosyorum gestio. Yung solutio indebiti, yan yung payment by mistake. Yan yung example kanina. Is a juridical relation which is created when something is received, when there is no right to demand it, and it was unduly delivered through mistake. Stated simply, there is payment by mistake. So yan yung nangyari doon kay TP kanina. There was payment by mistake to him. So yan na yung quasi-contract. Next page. Delict. Delict is an act or omission punished by law. It is generally referred to as criminal offense. Civil obligations arising from criminal offenses are governed by the penal laws. Yung pinag-uusapan natin dito ay civil law, civil code. Wala sana tayong concern doon sa criminal law na sa revised penal code. Kaya lang nagkataon dito na yung crime committed is a source of civil liability. Yung criminal offense ay source ng civil liability. Say for example, si Y stole the watch of X. Ninakaw niya yung relo ni X. So dito, merong crime committed. Say that is theft, yung crime committed. So that is an offense. Pag merong crime committed, dalawa yung liabilities. Criminal liability at saka civil liability. Yung criminal liability ay para sa state yan or the government. Yung civil liability ay para sa private offended party. Yung crime kasi committed is an offense against the state. That is an offense against the state. Kaya nga yung title ng case na ifa-file against Y ay People of the Philippines versus Y. Hindi yung X versus Y, but People of the Philippines versus Y. Because yung offense niya is an offense against the state. So, maniningil si state doon or si government. Yan yung kanyang criminal liability. Si X dito ay private offended party lang. So, sa kanya, yung civil liability. Say for example, Y was convicted of the crime of theft. He was sentenced to be imprisoned for 5 years. That is his criminal liability. That is for the government. Tapos, inorderan ng court si Y to return the watch to X. That is his civil liability plus damages. So, mapupunta yung civil liability or civil aspect dun kay X as the private offended party. Civil liability arising from delict. The revised penal code says that any person criminally liable is also civilly liable. The criminal offense is a source of civil liability. The offender is liable civilly to the private offended party. There are crimes, however, which have no civil liability. So, hindi naman lahat ng crimes ay merong civil liability. Say, for example, illegal possession of firearms. Wala namang private offended party yan. Mere possession of an unlicensed firearm constitutes crime na. So, hindi naman lahat ng crime committed ay merong private offended party. So, hindi lahat na crime committed ay merong civil liability. Components of civil liability: restitution, i-restitute, ibalik. Reparation of the damage caused, i-repair. Indemnification for consequential damages. Yung private offended party pwedeng mag-claim ng moral, exemplary, nominal, or nominate, temperate, actual damages from the offender. So, yan yung indemnification for consequential damages. Quasi-delict. Quasi-delict is one which causes damage or injury to another. There being fault or negligence, but there is no pre-existing contractual relation between the parties. There being fault or negligence. Ibig sabihin, walang intention to cause harm. Kasi pag merong intention to cause harm, the source of obligation is delict. And there is no pre-existing contractual relation. Kasi pag merong pre-existing contractual relation, yung source ng obligation ay contract, hindi quasi-delict. If there is criminal intent in causing damage or injury to another, the source of obligation is delict. If there is contractual relation, the source of obligation is contract. Quasi-delict is also known as tort, other terms, or culpa achilleana. Among the 5 sources of obligations, ito yung parang sikat. Ito yung broad na coverage. Ang daming mga examples ng quasi-delict. Magsasite lang tayo ng 2 examples. Say for example, si X ay owner ng tree, puno, na halos babagsak na. Nandito yung fence. Dito yung lot ni X. Merong tao na dumadaan dito outside the fence. Si X dapat paputol niya na yung puno na yan. Dahil pag merong nabagsakan, magiging liable siya under quasi-delict. Sa isang araw, nung dumaan si Y, nabagsakan siya doon ng tree. Liable ba si X? Liable siya under quasi-delict. Dapat pinaputol niya na yan. Another example, say, si X ay owner siya ng mga goats. Hundreds of goats. Dito sa land ni X. Yung land niya, kung saan nandun yung mga goats, ay naka-fence naman. Tapos merong gate dito. Pero isang araw, nakalimutan ni X na isara yung gate. Yung mga goats lumabas at pumunta sa plantation. Merong plantation si Y. At kinain ng mga goats yung plantation ni Y. Liable ba si X dito? Liable siya under quasi-delict. So, hindi niya pwedeng sabihin na kasalanan ng mga goats. Dahil dapat sinecure niya yung mga goats niya. So, hindi niya pwedeng ipasa yan. So, liable si X to Y under quasi-delict. So, yan na yung part 1 ng Law on Obligations.